Hi everyone, and welcome back to season 3 of Commerce Meets Law, a podcast we talk about various commercial topics and how they interact with the legal profession. This season is all about people who have broken barriers and stereotypes, who've not just stepped outside the box, but shown that these boxes simply do not exist. Happy New Year to all of the Commerce Meets Law listeners, and hope that you've all had a brilliant start to 2025. Today's conversation is with someone that I had the pleasure of meeting at Landmark Chambers during a mooting competition last November. Our guest for this episode is Nick Grant, a barrister at Landmark Chambers specialising in planning and infrastructure, compulsory purchase, and environmental law. Nick was called to the bar in 2016 after having completed his undergraduate law degree at UCL, a master's in law at Harvard, and various roles including working in the financial sector and being a judicial assistant to Lady Justice Arden at the Royal Courts of Justice. Nick completed the first part of his pupillage at Atkin Chambers before moving to Landmark Chambers for his third six. After listening to him speak about his journey and all the advice that he had to share for aspiring barristers during the day when I did the moot at Landmark, I knew that that conversation needed to be brought onto the podcast for all of you amazing Commerce Meets Law listeners. In this episode, we discuss firstly Nick's journey to pupillage and all the experiences that he gained along the way, what pupillage actually consists of, and how you transition from being supervised to managing your own workload as a barrister, why Nick moved to Landmark Chambers for his third six, and what his current work consists of on a day-to-day basis in terms of the tasks and also how often he goes to court and all things like that, and finally all his tips for aspiring barristers, including the common mistakes most applicants make, finished off with an elevator pitch for why you should apply to Landmark Chambers. Just a quick request before we get into the conversation, I'd really appreciate if you could kindly give the podcast a follow and a rating on Spotify. The higher the better, but I leave the rating up to you as it really helps Commerce Meets Law reach more listeners. Without further ado, I really hope you enjoy this conversation, and I'll see you right at the end. Hi Nick, and welcome to Commerce Meets Law. I'm super excited to kickstart 2025 with an episode with you and really looking forward to our conversation. And I just wanted to get started, firstly, just so listeners can have an idea of your background and who you are. Can you tell us a little bit about sort of your journey to law and when you first thought that this could be a route for you?
Sure. I'm afraid I'm one of those incredibly boring people that sort of fixed on wanting to be a barrister when I was about 8 or 9. I have no idea why. I don't have barristers in the family. I can only assume that I saw it on a TV show and thought, oh, that looks good, but I have no distinct memory of it. It's been sort of an overriding thing that I wanted to do. I had flirtations with going into the armed forces when I was at school because I wanted to fly planes, but they discovered, in fact, I didn't know this, that I was short-sighted and colourblind, and that will pretty much put paid to your career as a pilot. And then a brief flirtation with management consultancy when I was an undergrad. But frankly, I missed the law too much. So it's always been, therefore, wanting to be a barrister has always been something that I've been particularly interested in. And the law in general, I've always been kind of caught up in the idea of trying to figure out what the best framework is, if I can put it that way, that best helps people achieve what they want to achieve, but starting from a kind of within a framework that should be fundamentally fair, at least giving everyone an even chance. And that is what the law should do. Whether it does or not, it's obviously a different question, but certainly that's my view about what the law should do, at least.
And was it always the bar that you wanted to, or did you go sort of explore the sort of solicitor part? Because obviously there's that sort of differentiation of what profession people do end up going into.
So I always wanted to be a barrister. When I was an undergrad, a large proportion of my friends and other law students were going to become solicitors. So I thought, I'll see. I did a vacation scheme at a firm that was then Oldswang LLP, but is now was merged and is now part of CMS. And I sat in the IP seat. I really enjoyed it. They were nice people. It was interesting work, but I realised over the course of the sort of week that I was there that it just wasn't what I wanted to do. I wanted to do the advocacy. I wanted to be at the sharpest end of things, which is where I think barristers usually are.
Yeah, definitely. And I think that, it's a path I think people should definitely explore sort of when they get into the law, because I think both of them can offer very different sort of lives and paths and benefits. And I think ultimately it comes down to the sort of work that you want to do and the sort of like lifestyle that you want to have as well.
I agree with that. They are, I think for a lot of people, they just see the term lawyer, but actually being a barrister, particularly a
Yeah.
self-employed barrister and being a solicitor in a firm are fundamentally different ways of life.
Yeah.
And whilst they're complementary, they are very, very different.
And one of the reasons that I really wanted to bring on sort of more barristers on this podcast in general is because I think that there is a lot of conversation about, the path to getting a training contract and going to becoming a solicitor, whether that's to do a vacation scheme or a TC application. But I think that the pupillage path is still somewhat, a little bit. It's a little bit opaque, and there's still more that can be explored within it. So I wanted to sort of learn a bit more about your journey and for our listeners to learn about it as well. So could you tell us a little bit about what your journey to pupillage was like and sort of what experiences you gained in order to have a successful pupillage application?
Sure. So I kind of gave up on going to the bar in at the end of my first year at uni because the kind of bar the perspective was, and I don't think this is actually true, but the perspective that held sway was if you don't get a first, you don't have a chance of going to the bar. Now, I don't think that's right,
Mm.
but that is what I thought. So, my second and third year, I explored a lot of other things. I said management consulting for one, but that sort of meant that rather than doing sort of mooting and debating at university, I was doing other things. I did a lot with our law society, which at UCL, which is where I was, um, ran a lot of events, both social events and mooting, debating, negotiation, various things, sporting events. But I was involved, so I was involved in running that and being effectively a trustee of that and its budget, which back then was quite significant. So I think that helped to the kind of just general responsibility, if I can put it in that way.
Yeah.
Um, I then left uni, ended up getting a first, um, and thought, oh, I might be able to do this bar thing. And I've decided I wanted to do a master's. I didn't come from a background where we had multiple thousands of pounds just lying around, so I went to work in a bank for a year. Um, so back when I was doing this, which will date me horribly, but this is 2013, 2014. And about that time, the then Financial Conduct Authority had said a lot of banks had been effectively mis-selling interest rate derivatives. And so they were ordered to put together a huge review of all the interest rate derivatives they'd sold. And I went to work as a contractor for what was then Lloyds Bank Commercial Bank on that. Um, and that was helpful in a number of ways. One is I thought I'd end up wanting to go into commercial laws, and it was a really helpful background in financial regulation and commercial institutions. Secondly, though, my particular role ended up being um, effectively I'd get papers and interviews relating to how a particular product was sold to a particular company, and I had to put it all together and summarize it for the decision makers within the bank who were going to take a view as to whether they were going to, offer compensation or whether they thought the sale was fine. And all of that had to happen in quite a short turnaround. So it gave me the ability to flick through papers, get the evidence out of people that I needed to get it out of, and put that together in a clear, easy to follow, and comprehensible manner, and then present that very clearly to decision makers, one of whom was a solicitor, one of whom was a financial regulatory compliance officer, one of whom was sort of pure commercial banking, a banker rather than one of the support functions. Um, so, having to pitch it to a number of different audiences. Um, it also gave me the ability to, frankly, get on top of spreadsheets in Microsoft Excel and figure out how that works, which can be quite helpful every now and then. Depends which area of the law you go into, but I still, come up with some spreadsheets. Um, so that was quite helpful. And then I went and did a master's. I did that out in the States. Um, when I came back from that, I thought, okay, I need to do lots of mooting and debating because I hadn't done that at uni for the reasons I've outlined. So joined my own of court, did the bar course, did moots and debates through my in, through the then provider, because it was before the Inns of Court College of Advocacy. Um, got an offer of pupillage during that year,
Mhm.
but it was going to start not at the end of the bar course. So I had a year's gap. So I applied for and became a judicial assistant for a year. Um, And that, again, that was incredibly helpful. I was in the Court of Appeal and working for the then Lady Justice Arden. And it gave me a real insight into how the Court of Appeal works. I got to see a lot of appellate advocacy, some good, some surprisingly not so good. Got a really good understanding of how judges work and what they're looking for in the papers, particularly judges under pressure in the Court of Appeal, because there's a large workload there. Similar points of digesting large amounts of papers very quickly and putting together a memo for the judge on, look, this is the case, this is what they're arguing, this is where you find all the references, which is a really important skill for the bar. And then really getting to grips with how the judges are thinking about the law and what they saw as the important points versus what I, as obviously a much less qualified person, thought was the important points. So that was a really great year. And anyone thinking of the bar, or indeed solicitor, we had some solicitors who were JAs the year I was there. It was a really, really rewarding, really enjoyable year. Did pupillage. So I went to pupillage in a construction chambers, and that didn't work out. I realised about halfway through that it was an area that didn't really agree with me, and I didn't really agree with it. And also, being completely candid, there was an element of self-development that I needed to do that I hadn't quite got yet, because there is a big change from going from I'm a student and let me show you how clever I am with my essay and how I've thought of these things, to being a barrister where you're like, my client doesn't care about any of that. They want to know there's this £2 million claim. It's going to take £1 million to fight it. It's really hard, so settle for X. A lot more practical. And I just didn't get to where I needed to be by the end of that year. So didn't get taken on there. Went to Landmark for my third six, and have never really looked back. I'm very, very happily ensconced there. So I joined Chambers in 2019. And I've been there through, the years of COVID and now not so COVIDy. So that's kind of my journey.
Yeah, thank you so much for that. I think that really highlights the variety of experiences you've had. I think that there's a misconception that perhaps if you want to go into the bar, all you have to do is get a first at uni and then go do a master. And whilst that's important, I think that practical angle of whether it's in the law or outside the law can be just as helpful in helping you gain those skills that ultimately sort of make you a better barrister. I wanted to talk a little bit about your time kind of during pupillage, because I think that a lot of people don't really quite know, there's one part getting to pupillage and then knowing what you actually do whilst you're there. So could you give us a couple of examples of what you did as a pupil and sort of what your day-to-day tasks were?
Sure. So I should preface this by saying pupillage is very different in very different chambers. It's not, I mean, my view when I was applying for VAC schemes was training contracts are all largely pretty similar. Some have 4 seats, some have 6, but there's a degree of similarity. Pupillage is very different in different chambers because they're all very unique organisations, and run things differently. So when I was a pupil at Atkin, it was sometimes doing. So I would be sat with my supervisors, and sometimes I would help them with cases and work they were on. So they'd say, can you do me a research note on this legal point, for example? And I'd go in, look that up. And sometimes it would be what was known as dead work, which is basically, here's a set of papers. I want you to write the opinion that I wrote 2 years ago, and then you'll get to see mine and I'll get to see yours and I'll assess it. And that was pretty much all, a mixture of it, plus various assessments and advocacy exercises, which I'll come back to in a moment. Landmark was kind of similar in as much as there were mixtures of working on the things my supervisor were working on and sometimes doing work that they'd previously done. But it's kind of the work products that you often send out as barristers are opinions, which is effectively someone gives you a set of papers and says, can you advise on this question or this question? Pleadings, which are the formal documents that you have to draft if you're going to issue a claim in court. Skeleton arguments, which are the documents you draft ahead of a court hearing. There'll be various others again, depending on the various different areas of law, but those are kind of the big bits, if you will. So it was drafting a mixture of those, and then when I was at Landmark, certainly they took the view that my third six should have a big practicing element to it. So I was, after my first seat, which was property, I started going and knocking about the county courts, doing things like possession claims and very basic property claims as well, and worked that up into covering for other people who had small hearings that they needed covers that they couldn't make. So I'd start doing that, case management conferences, etc., and then working that up into small claims trials, a bit of everything to start with. And that's pretty much as far as I got when I was a pupil. I think after that, you work up further into other trials in other courts. But it's that sort of thing basically. So it's producing those products. Then on top of that, you have assessments normally. Again, that will vary set to set. So at Landmark, there is a formal written exercise, anonymised written exercise at the end of every seat, and then we also have two advocacy assessments where the pupils will experiment with doing a bit of cross-examination, that sort of witness handling advocacy, and high court submissions based, kind of like a moot type advocacy. So that's kind of how pupillage ran for me. At Atkin, I had 3 seats before my decision was made, one with each supervisor. At Landmark, you have 4 seats, but 3 of them are pre-decision, and it's one in each of our practice areas: property, planning, public. And then our 4th seat can be a bit more fun because you've either been taken on or you've not, and it's about what skills do I want to develop, where do I want to see, what do I want to see.
Right. And I think that's, super interesting for you to highlight as well that unlike perhaps training contracts, particularly within commercial law, that every chambers can look very different, even if it's in the same area of law. And I think that people should bear that in mind when they're obviously considering where they want to apply and, sort of where they can see themselves. In terms of that transition from having a supervisor when you're a pupil to even perhaps that sort of the latter half of your pupillage, how do you sort of develop the confidence to then go from knowing that, before there was someone overseeing your work to now, ensuring that you're doing the best for your client, but there's perhaps no one kind of there telling you maybe this is going a bit wrong or maybe you should consider this direction?
It's actually a pretty terrifying change, if I'm honest.
Yeah.
So at least when you're still a pupil, you're on your supervisor's insurance, and there's always someone you can go to say, look, I know I'm doing this hearing alone, but can I talk it through with you?
Yeah.
I think when you're a very junior barrister, it starts to depend quite heavily on how your chambers is. We're lucky in Landmark in that it's incredibly collegiate, all the way up and down. And so if I've got questions, and there was no one I couldn't ask from the senior silks downwards, and the junior end has been and still is incredibly supportive. So when you're looking at these thinking, am I being an idiot? Or when you've got a solicitor who's saying, no, you should do this, and you're looking at this thinking, this isn't right, but am I wrong? There are people you can talk to.
Yeah.
And I think that's a really important part of it. Also, you have to get comfortable with the fact that you'll screw stuff up. Everyone does. It's what insurance is for. No one likes doing it. You don't want to be a person that doesn't care. But I think a lot of the difficulty that juniors have, particularly actually in the pupillage year, is they've been so successful so far that they then when they start being told this piece of work's not good enough, whether it's assessed work or whether it's, your own high court trial, not high court trial, your first sort of steps into taking into court, some can really spiral and just don't get that confidence back. So being able to understand that however good and brilliant you've been so far, and most people getting to the bar have been, you will get it wrong, you will screw it up, and we will do it. The key is to make sure that, very little is unscrew-upable. Some things are, but very little is unscrew-upable. And if it is unscrew-upable, that is what insurance is for. So you've got to get comfortable being outside your comfort zone and realizing that you could get it wrong. And I think that's a really important thing for people to learn coming to the bar. And that's probably the hardest transition. But it's, either sometimes you don't have a choice. Sometimes you do really just screw up and you get your corners knocked off, and then you realize that your career is still fine. Then that makes a big change and is in many ways quite reassuring.
I think that I've always had this feeling of any barrister I've spoken to on this podcast or outside of it, that this feeling that, everyone seems so articulate, they seem sort of so knowledgeable about their area, that I think it's really good for younger people and people considering the bar to know that it takes time to get there, and if they make mistakes along the way, that's part of the journey. Just like any other profession when you're sort of starting off. And I think that that's probably relieving people to hear as well. I wanted to talk a little bit about your current practice and what you do, just to give people an idea of what a part of life at Landmark can look like. So, in terms of your specialisation, can you tell us a little bit about your sort of main expertise and work and what sorts of clients you work with?
Sure. So I specialise in planning and associated areas, so planning, environment, compulsory purchase type law, and bits of local government. So all of that centres around largely the Town and Country Planning Act 1990. Basically, if you've got a piece of land and you want to build something on it, you need planning permission. And this is the law around getting planning permission and appeals to the Secretary of State, because you initially apply to your local authority, and if your local authority says no, you can appeal it to the Secretary of State, and a planning inspector comes along and looks at it. A lot of our environmental law, particularly our really strict EU derived environmental law that came from the EU, is incorporated in the UK through this process, because
Mhm.
it's you need the consent in order to build. Um, and so that's a large portion of environmental law. And then compulsory purchase is basically where the government comes along and says, I want to build a railway line. You have houses in the way. You're obviously not going to sell to me. So I'm going to forcibly buy your house. You'll get fair market value, but I am taking this house. And that's sort of the third kind of big, big branch to it. In terms of what that looks like on a day to day basis, in terms of client base, I act for objectors, acquiring authorities, those promoting CPOs, developers, those trying to get planning permission, local authorities in particularly in appeals. So the local authority said no, or hasn't made a decision, and the appellate, the developer's gone straight to the Secretary of State. That can often lead to something like a planning inquiry, and so which is a bit like a trial in that there's statements, cross-examination, submissions. So representing local authorities, appellants, and objectors in those. Um, and I work for the government, so defending decisions, because once an inspector's reached a decision, someone can seek to basically statutory review it, which is like a judicial review. So it's not the inspector got it wrong on the merits. It's a was it illegal, irrational, procedurally improper. The kind of the Wensbury type public law fetters that you'll be familiar with from public law, because basically planning is public law in this specific context. Um, so to give you a pretty well, not typical, an enjoyable idea of what my first 3 months of this year is like. The last 2 weeks of January, I'm in a planning inquiry for 2 weeks against a silk who was in fact my pupil master when I was a pupil supervisor when I was at Landmark. All to do with whether a care home should be built in Beaconsfield. Then I'm in the Supreme Court on a complex point of interpretation about some EU-derived environmental law. Then in March, I've got two inquiries back to back. One is for a local authority where an airport has basically rocked up and said, we've been in breach of conditions on our planning permission for 10 years. So it's all about whether planes can fly at night. They say we've been flying more planes at night than you let us do. We've done it for 10 years. So basically you now can't enforce against us, and it's totally fine for us to fly all these planes at night in the future, and we're fighting that. And then I leave that and go into another planning inquiry where I'm for the developer, and we've got a site in Brighton, and we want to turn it into some nice, housing, and the local authority has said no, and a lot of local people have turned up and said no, we don't like it either. So that's kind of and all around that, I've got various bits of paperwork and advice that I need to do. So one of my clients has got a planning permission, and that's now being challenged via the court route that I talked about earlier. So I just spent sort of this morning finalising a pleading for that, because as the developer, we can rock up and say, no, the Secretary of State was right. I've got to review a local authority's decision whether to grant planning permission before they do, to see if there's any legal errors in it. I've got just received a statement of case on a compulsory purchase case where my client had acquired the land, and this is all about what's fair market value, how much money they would have made. So we've got some fights going on in the upper tribunal lands chamber about how much they're actually entitled to. So all of that's going on in the background around these kind of bigger hearings. So that's kind of what my first 3 months of this year looks like, and that kind of gives you an indication of what practice at my level, which I mean to be about 5-6 years in.
I think that it really highlights the variety of sort of things you're doing, even within that sort of, one specialization. And I think that it's important for people to understand as well that it's a mix of, whilst there is obviously going to court, but there's also planning inquiries and sort of working with clients and lots of different aspects to that one role. Out of all of these sorts of, various cases, various types of clients, and I guess also sort of various levels of where these cases are being pleaded, what would you say, from your perspective of your role, is the most sort of rewarding aspect of it, the one you enjoy the most? And one that you continue to find quite challenging?
You know, it's really hard to say because they were all interesting but really challenging in very different ways.
Mm.
So the government stuff is always fascinating because it's usually difficult, hard-edged points of law. It's like a moot. You're going in, you're trying to change, well, not or trying not to change the law, or change the law, and figure out what the law is. And so intellectually, that's incredibly stimulating. On the inquiries front, if you're doing a planning inquiry for an appellant's team, usually the appellant has funds. So you're in a big team, everyone knows what they're doing.
Mm.
They're extremely competent, often people at the top of their game. It's a really enjoyable experience because, your witnesses have all done it for many, many years. They know what they're doing.
Yeah.
They can provide you with a lot of support, and that's, it's actually just quite fun. Um, by contrast, when you're doing an inquiry for a group that, for example, has no funds or really inexperienced witnesses, that in many ways is much harder. It's much more challenging. It's a lot more stressful. But it means that when you do a good job on something, you really feel it because
Mm.
you've made that work. Um, I had an example. I had a really difficult inquiry last year, um, and one of on a particular point, one of the silk on the other side came up to me afterwards and said, "Your cross examination on this point was really, really good," which was really nice to hear,
Mm.
because it was a hard point to run, and it's like, okay, that's nice to hear when you feels like, okay, I've actually done something well, and someone else has seen that, even
Yeah.
whatever the strengths or weaknesses of the case. Um, so they all have their challenges and their difficulties, but they all really rewarding just in very different ways, and that's why it's quite fun having a mixed practice. You see some that end up really specializing, so only doing, for example, government work or only going around doing inquiries. I mean, and those come with different financial profiles, because obviously we're self-employed, so there's no salary.
Yeah.
But for my part, at the moment, at least, it's enjoyable to have all this mixture precisely because they're all enjoyable and rewarding in completely different ways.
Just on that aspect of being self-employed, I think it's a question that, again, a lot of people have, and perhaps a concern as well, whether they want to go into the bar of, whether it is as financially secure and whether work is always coming in. Just in terms of the process at Landmark, could you talk a little bit about sort of how that process happens of work coming in and how much of a sort of a choice or time frame you have on what you're accepting it and when you're accepting it?
Yeah, of course. So when you're relatively junior, work
Mm.
generally comes to Landmark rather than comes in your name. Sometimes it does if you've really built your profile on something, but a lot of the time,
Right.
you get people going to Landmark saying, "We've got this problem. We need a junior of 5 to 7 years cool or 3 to 5 years cool." Within that, we at least have a policy of fair allocation of work policy. So the clerks will allocate it, but we have internal policies to try and make sure they're not always going the most interesting, juicy cases to the people they like most. So that's kind of how it works for us.
Mhm.
In terms of what I have to say yes to, barristers have the cab rank rule, which means if someone's offering a reasonable fee and it's work that I'm competent to do and I've got the time to do it, I've got to take it.
Yeah.
Um, so subject to that, you can turn work down if you think if it's not something you're competent to do. So, for example, I've turned away work because it was immigration work and I know nothing about immigration law, or
Mhm.
it's a complex bit of property law, which I used to do when I was younger, but I don't do anymore, and so I'm just not competent to do it. And then it's a matter of, well, can I fit this in? And that is something that I think changes the older you get and the more relaxed you get in your work, because it's when you're
Mm.
younger you want to cram everything in because you want to meet
Yeah.
as many people as you can, make as much name as you can, and you think, this can't possibly take anyone more than 4 hours, and then you do it and it takes 10, and you're like, oh God, I feel awful. Whereas I've certainly got more comfortable thinking, actually, I'm doing this. This is a lot of work. It's going to take me at least 3 or 4 days to do, or I've got 3 or 4 days work in my diary. So the most I can give this is 5 hours. Looking at this, is it 5 hours worth of work? No, it's not. I'm just going to say, I've got to say, I'm sorry, I'm too busy. Um,
Mm.
because whilst we have the cab rank rule professionally, you are entitled to your weekends and your evenings and to take holidays, and so you're allowed. That's allowed. You don't have to just be there available 24/7. Um, and So that's really how it works. It's that kind of caveat rule, subject to making sure that you have a bit of a work-life balance and know that you can. I for example, tend to stop work at 6 every day now because I've got a partner and a dog, and it's nice to spend time with them rather than sitting at my desk for 12, 13 hours a day.
Yeah, I think that that's such a sort of key point that you made, especially when you're in an industry or in a profession which is self-employed, and particularly when you're younger, you feel like you want to impress, you want to learn, and so you try and do as much as humanly possible, and maybe even take on more than that. But as you get more comfortable in your own specialization and you sort of know how long it takes you to do certain things, I think that you sort of definitely learn, and it's a process that it's hard to know. When you're in education, it definitely comes sort of the more you do it and the more you are at work. I think I sort of really wanted to talk about the other aspect of your role as well, which is something you discussed when I had the pleasure of meeting you at Landmark, of talking about sort of the training aspect and bringing newer and younger barristers into the chambers. So, in terms of questions from sort of aspiring barristers and questions that they generally have before entering the profession, from your perspective, what are the sort of most common mistakes you see when you are reviewing pupillage applications, or sort of when you see pupils coming in who really, really want a place at Landmark?
In terms of sort of common mistakes, things like putting the wrong name on an application. I've been there. I remember that a lot of them are very similar, so there's a lot of copy and paste. But actually, if you
Yeah.
apply to us saying I'm applying to Francis Taylor Building because I'm good for you. But we're not FTB. So attention to that sort of detail at the end, and it's really hard when you're doing these applications because you're doing so many of them. But actually, go back at the end, check you've got the right names, check your spellings right, check your grammar. That basic. Give it a read through at the end, or ask someone else to give it a read through at the end, because that can make a big difference. It needs to be clear from your application form that you know what the bar involves and what we as a chambers do. And I think one of the issues is not necessarily specific to us, but a lot of chambers will put on their website, we do this, this, and this. And actually, if you look at the third one person out of their chambers does it sometimes, and they
Yeah.
they want more work in it, and that's fair enough, but they don't actually do it. So I think perhaps if you really want to understand the chambers, mini pupillages are good. If you can't do them, look at where it's featuring in rankings of things like Legal 500 or Chambers and Partners, because that gives you a good idea of where its prestige is. Now, again, it needs to come with a health warning that not all chambers participate in these things. So there are some very good chambers that say this is a racket, we're not taking part in it. But a lot of chambers do, and it will give you a good indication of where those chambers, what their strengths actually are, rather than what perhaps they profess them to be. And yeah, no, showing that you know about the bar and what it entails. So by the time you're applying for pupillage, most people, to be fair, do, because there's quite a lot of self-selection that happens, and so it's rare that it's obvious that someone doesn't understand what the bar is like, but it is something that's important. Again, ways of understanding that: mini pupillage, looking at online resources, looking at sort of chambers virtual open evenings, that sort of thing, all can be very helpful, and there are quite a lot of those now. And yeah, show that you understand us. So partly comes back to the point I was making about what areas we're strong in, but the candidates that I see that clearly know us are the ones that can also tell us what cases we've been in, why they found it interesting. Really understanding that real depth of that granularity, basically about us and what we do, and then being able to tell a compelling story about you at the end of the day. I think one of the difficulties, or one of the questions I get a lot is, what do I need to do to show I need to be a good barrister? And that's hard because we don't have a checklist. What we need to see is what your role is. Bear in mind your pupillage application form is a piece of advocacy, so you're there advocating for you. So to tell us the compelling story as to why you're the right fit. And I don't mean, are you a jolly good chap? I mean, have you done? What's your advocacy experience? Do you like advocacy? What can you do to show us that you like advocacy? What is your experience? Are you good at advocacy? Again, what can you do to tell us to show us that you're good, rather than just telling us that you're good? our area of law? What can you do to show you're interested in our area of law? For us, for example, if someone rocks up and says, look, I sat through a 2 week planning inquiry, you go, okay, hardly anyone does that. That's really interesting. So I think, but we're not looking for, have you done 3 mini pupilages? Have you got to the quarterfinals of at least 2 competitions? Anything, mooting competitions, anything like that. We really don't have that checklist. It's trying to figure out the way that you can show, based on the work and experience that you have done, that you can satisfy our requirements. And again, I don't know if they still do this, but Matrix Chambers used to put their at least initial SIFT criteria online. And if that is still about, I would suggest that's worth looking at, because again, it'll be different for every Chambers. It's not written in stone across the whole bar, but it gives you a helpful indication of roughly where sort of people are and where you want to be pitching and what kind of things you want to be thinking about.
I think we've picked up a lot of boxes there, and I think the other aspect is also, just like any other company or profession you want to be joining, it's a two-way street of you want to be a right fit for the chambers or the firm, and vice versa. So I guess just before we do the rapid fire, since we've been talking about Landmark, if you could give us an elevator pitch on why someone who is an aspiring barrister should consider applying to Landmark Chambers, what do you think you'd say?
I'd say two things. First, for the kind of work we do,
Mhm.
environment, and property, actually, we're very much at the top of the tree. So you will get the most interesting work that you could possibly get in this field in our set. I've been doing this for 5 years. By March, I'll have been in the Supreme Court twice. I'll have represented the UK both led and unled before international UN compliance committees, and I'll have been led and unled in the Court of Appeal, the High Court, planning inquiries, the Upper Tribunal, Lands Chamber, and in major DCO examinations. Like, that is a great quality of work, particularly for someone who's as junior as me. So the first thing is quality of work. Second is the collegiate atmosphere. We are a really, really nice set. And that is fundamentally really important. And that is not just in the people at my level are nice, but that's true. It means that if I'm stressing about something, I can talk to someone, at whatever level they're at. It also means that when something goes wrong in your life, Chambers is very quick to adapt. So when I was a third six pupil, for example, my dad died. He unexpectedly he got cancer and died, and Chambers could not have been better or more supportive throughout that process. That kind of, we want to do well by our pupils and indeed by junior tenants, basically runs through the heart of Chambers. And I think between those things, they're kind of the atmosphere and just the fact that everyone's so damn nice, and the quality of work we do. If we do the kind of work you want, you'd be hard pressed to find a better set.
I think that's brilliant. And having had the experience of meeting some people at Landmark myself, I think that, like you say, the quality of work is so key, because obviously that's part of your profession. But equally, if you're spending a lot of time somewhere, you want to make sure that you like the people there and you enjoy working with them. And I think that's such a key component of wherever you decide to work, for sure. We always finish with a rapid fire, and we have three questions before we finish off the episode today. So the first question is, what is the best and worst advice you've ever received?
Best advice is really hard, because there's been a lot of good advice. I think the things that have two things that have stuck with me actually didn't come from advice. They came from watching actors talk about films and the films they're in. Because obviously when you're young, you get a lot of tough cases, and it's
Yeah.
very difficult to sort of think. So the first one was Christopher Lee saying, "We all have to do awful films at some point. The point is not to be awful in them," and that really struck with me, and really helps when you're having to do not shit cases, difficult cases. And the second one, I've completely blanked on. Oh, the second one is watching Stephen Colbert, who's an American late night host. Somebody was asking him about his background, and he used to do a lot of improv. And he said the best advice he received is learning to love the bomb, learning to love it when you're doing something and it's not landing and it's not funny, because most people shrink from that. And he says when you can get comfortable with that, you can transform your relationship with the work that you're doing. And a lot of that is applicable to being a barrister as well. We so often want to be brilliant and conduct a devastating cross-examination, but it can feel feel it very emotionally hard when you're doing a hard case and it's going badly. But if you can learn to change that relationship, it makes a huge difference to just your quality of life. So those are the two best bits I think I've seen. I don't think I've received any bad advice, to be honest with you. I've only ever received good advice, which I've been very grateful for. Or I did receive bad advice and ignored it and therefore can't remember it.
That's the best way to do it. I think worst advice should probably not be remembered at all. The next one, since we spoke a little bit about work-life balance during the conversation as well, now I guess owing to the fact that there should be a bit more work-life balance as a goal for everyone this year, what does an ideal weekend in your life look like?
Um, get up, go for a nice walk with the dog, or a nice run with the dog and my partner. Um, Go to the gym in the afternoon, pick up some food, cook dinner for us, spend the rest of the time watching film or playing video games.
I love that. Sounds amazing. And the final question is, if you could relive one day of your life, which one would you choose?
That's really hard. I have no idea.
Are there a couple, maybe, or is nothing
No,
springing to
just
mind at the moment?
it's. I remember sort of the days. Like I remember real high points, but often they were surrounded by also real low points.
Right.
So it's and I can't pinpoint a day where I thought, oh, this has been one of the best days of my life. Um,
Perhaps it's yet to come.
yeah, maybe. Um, So yeah, no, I'm sorry, I can't help with that because I don't know if I would relive any day. I'm very happy with the life I've got. I'm very lucky about it, but I'm not sure I want to relive any of them.
Yeah, I love that. I mean, it's a response we haven't had, so I love the fact that it was such a creative answer. And on that note, Nick, thank you so much for coming on the podcast. It was really, really interesting to hear about your journey, about your current work, and also I think there's so much advice in there for anyone who is considering the pupillage, whether at Landmark or elsewhere. So thank you for giving us your time today.
No problem. Have a lovely rest of the day.
And on that note, thank you so much for listening to this episode, and a massive shout out to Nick for coming on Commerce Meets Law. If you enjoyed this episode, please do let me know by emailing commercemeetslaw@gmail.com or with a DM on Instagram at Commerce Meets Law. We also now have a website with the same name, and I'll link it down in the description where you can find the podcast episodes, our YouTube channel, and all of our social media. This is something that I've wanted to have for a really, really long time as like a one-stop shop to find all of the CMA content. So I'm really, really excited for all of you to have a look at it and for all of you to reach out on our various platforms through the website as well. For now, take care, goodbye, and I'll see you very soon on the next episode.